already got your mic open, we'll go ahead and get started. We'll have team 3. We're going to have you guys pick the first category, and what'll happen is I'll go ahead and click on whatever you choose. But we have 5 categories here, so it's the first round is going to be on amendments, bylaw enforcement, collections, insurance, and name that association or the category. So Jeanette, why don't you go ahead and pick one of these categories and get us kicked off?
Well, let's do collections.
All right, collections for what number?
300.
All right, so here we go. The procedure that occurs when a co-owner fails to pay a lien.
So if you know the answer, just type it in the chat.
Yeah, and don't forget to put your team number. Okay, so team 1, foreclosure. So that is correct. So whenever you're going to put a condo or an HOA lien on, what end up happening here is that the answer is, so what is foreclosure is what the answer is. So that's what you do when somebody doesn't pay for their lien. So okay, very good.
Well, I'm going to argue for our points. I said it out loud, so you can't say it out loud. You have to put it in the thing.
You got to put it in the chat, because that way, otherwise, it may be difficult for us to tell who said it out loud.
Okay, sorry.
I have a question. So how do team members communicate?
Well, we basically, whatever team you're on, I mean, there isn't going to be communication. It's just whoever the first person is from a particular team that puts in the answer, their team gets the points.
Oh, so the team captain doesn't do that, doesn't have to do that. It's just whoever.
Correct. It's just anybody.
It's getting competitive now. Okay.
Yeah, so say what team number you're on. But what I need the team captain to do, so that one went to team 1. So I need the team captain for team 1.
Yay, one.
The next category here.
I will pick bylaw enforcement for 200.
All right. A reasonable dollar amount of these are recoverable if permitted by the condominium bylaws.
Reasonable amount. What? A reasonable dollar amount. These are recoverable.
All right, so.
Oops. 2.
All right, so we don't have any of the correct answers. Yes, well, I'm going to go ahead and give it to team 3. Legal fees, I think, is close enough. But so basically, what you need in your condominium or HOA documents when you're enforcing the bylaws, it's a great tool to allow the association to recover reasonable attorney's fees. There was recently a case that came out, and the court did not award any attorney's fees just because they said it was a default judgment. And they said that they didn't think it was worthy of that, but the Court of Appeals reversed that and said that the trial court had to provide attorney's fees to the association as the prevailing party because that is what was required by their condominium documents. So I believe the correct answer on that one went to team 3. So we'll go ahead and move on to the next one here, and I guess Jeanette is the captain of team 3 if you want to pick another category.
Bylaw enforcement for 400.
All that money, you could have got it from Home Depot, probably.
Can you hear me? Bylaw enforcement for 400.
Bylaw enforcement for 400.
Well, I mean, the stoves I seen, there were 5.
All right, so
But they were really nice for 5.
We got to mute somebody.
yeah.
Kevin, I think you can mute them.
All right, so let me see if I can find who it is.
But yeah, just like I said, I just number, but like I said, somebody.
Looks like it's Eunice.
All right, let me see if I can scroll down and find her here.
No, he was trying to just come and do it all at at the same time.
Well, I'll call him when I get the stove. I guess tomorrow, hopefully.
There we go. Sorry about that, everybody. All right, so sorry, what one did we have for 400?
Bylaw.
Bylaw enforcement for 400. All right. All right. These can only be levied after notice and a hearing.
Oh.
All right, so, yep, team one, so fines. So that is the correct answer. So the important thing to keep in mind is the Condominium Act actually requires that you have notice in the hearing before you levy fines. I see a lot of associations or managers, they'll take the misstep and just automatically try and assess them without having any type of a notice or hearing. And so, and I even see some attorneys who aren't familiar with this area of law will try and put that you can do that in the condominium documents, but you can't do that because the Condominium Act doesn't permit that. So go ahead and keep that in mind. All right, so team one, I believe, got the correct answer there for 400. So you'll go ahead and be able to pick the next category.
Let's do amendments for 300.
All right, amendments for 300. The number of co-owners, all right, let's see here, sorry, got this. Required to approve an amendment to an HOA declaration without an amendment provision. All right, so we have 2/3, which isn't the correct answer to this question. We got to keep going. Got to keep going. Don't have the correct answer yet.
Johnny. Requires approve an amendment to each. Oh. Without amendment. You can't.
All right, whatever the answer is you got to put it in the chat function here. I'm going to give this another one 10 seconds, but we don't. All right. All right, so nobody got the correct answer to this one, so I guess this was a good question to put up there. So the answer is, what is unanimous consent or all of them? So that's one key area where a HOA is going to differ from a condominium. So if you have a condominium, the Condominium Act sets a 2/3 approval requirement, and sometimes you're going to need 2/3 mortgagee approval depending on what you do. If you live in an HOA with a declaration, we don't have a Homeowners Association Act in Michigan. So it's whatever the person puts into the documents, but if they do not put an amendment provision in the documents, the answer is that you would need unanimous consent in order to do that. All right, so since nobody got that one, we're gonna go, I think it was back to team one who had the last correct answer. If you wanna pick the next category.
Bylaw enforcement for 300.
All right. This happens if a co-owner does not remedy their tenant's breach of the condo bylaws within 15 days. Yes, team one, eviction. That is the correct answer. Good job, team one. So what the Condominium Act allows in most condominium documents is that if a co-owner has a tenant and they continue to violate the condominium bylaws, that the association actually has the ability to evict them. So it's a good remedy to use when you have a problem tenant.
Okay.
All right, so team one, since you got the last correct answer, you're gonna go ahead and choose the next category.
Oh, collections for 400.
All right. The recorded document that triggers a bank's obligation to pay assessment after the bank forecloses.
No, the recorded document. Lien? I don't know.
All right, so it's
Recorded document.
I was wicked fast with that, so.
so yeah, it's not the bylaws, and it's not, the lien is not the correct answer for this.
No.
No. Mortgage terms and foreclosure are pretty close, so I'm going to go ahead and give you the points on that one. So what the answer to this is a sheriff's deed. So there's cases out there that have held once that sheriff's deed is recorded, even though the bank may not necessarily have legal title, they have what they call equitable title until the redemption period is done. But the recording of that sheriff's deed, that's what triggers the bank's obligation to start paying assessments, and they have to pay starting during that redemption period. So we'll go ahead and give team 3 the points for that one. And somebody on team 3, if you'd like to pick the next category.
Well, wait a minute. Are you tallying the points? I don't see the points being added up.
Ellie's adding them up. So after we get through round 1, I'll have her give you a tally. And if we hit a daily double, I'll have her let whatever team, got that know how many points they could wager.
Can we do bylaws for 500?
You bet. A bylaw provision that permits an association to enforce a violation, even if they failed to do so in the past. All right. So see violation provision, but that's not the correct answer. All right. Doesn't look like we're getting any more. So on this resolution, nope. Any other guesses? Amendment? No. All right. So this one, I don't think anybody's got the points, but the answer is an anti-waiver clause. So typically at the end of your condominium bylaws, you're going to see some sort of a provision that says, even if we haven't enforced the documents in the past, that does not waive our right to enforce the documents in the future. And courts have upheld those and held them to be enforceable if you have a situation where the board may have been lax in the past. So keep that in mind. All right, so I think it goes back to team 3 if you want to pick the next category.
Let's just do bylaws for 100.
Bylaw enforcement for 100?
Yeah, yes, sir.
Okay. A legal remedy used to stop a co-owner from continuing to violate the condominium bylaws. Let's see. All right, injunction. Yep, team 3 is correct. So injunction is the appropriate answer to that one. So what is an injunction? Good job. So team 3, you want to go ahead and pick the next category?
Kevin, I think we might have lost your screen. Can anyone else see it?
Nope.
No.
All right,
Nope.
so let me see if I can, wait, stop sharing there. All right, back up again.
Yep. Got it.
All right, so team 3, go ahead and pick the next category.
Amendments for 200.
All right, oh, sorry about that. All right, the time period set by statute for mortgagee voting to amend condo bylaws. All right, so team 2, 90 days is correct. Whoever on team 2 answered for 90 days. So what the statute says is you have to have an affirmative vote of the co-owners, and once you have that affirmative vote of the co-owners, then you can go ahead and send out a notice to the mortgagees. If the mortgagees do not vote or not respond, it counts as a yes vote. So unlike the co-owner vote where you actually have to have an affirmative response, this one is kind of neat because you don't. So, all right, so what is 90 days? All right, so team 2, would you like to pick the next category?
Beth, I think that would be you.
There we go. Sorry. Let's go with amendments for 100.
All right, amendments for 100. The minimum number of eligible co-owners required to approve a material amendment to the condo bylaws. Yep, team one got it. So 2/3 is correct. So that's what's required by the Condominium Act and the condominium bylaws is 2/3 of all co-owners that are eligible to vote is what the statute requires. So you do not count anybody who would be delinquent or otherwise ineligible to vote in that calculus. All right, so team one, next category.
Sorry, insurance for 200.
Insurance for 200. A co-owner's insurance policy in an attached condominium. It's not a rider.
It's a,
Not renter's insurance. Home's pretty close. All right, I'm gonna go ahead and give this, let's see, no. I'm gonna go ahead and give this to team three, who said home insurance, but actually what it's called is an HO6 insurance policy. So an HO6 insurance policy, if you live in an attached condominium, that's gonna cover the contents and typically the paint-in. You're also gonna wanna make sure that your condominium documents have a provision in them that allocates primary responsibility in the event that there's overlapping coverage with the with the association's insurance policy. All right, so looks like that one was team three. If you want to go ahead and pick the next category.
Let's just do amendments 400.
Amendments for 400. The minimum amount of time to notify a co-owner of an amendment to a master deed before it is recorded. All right. It's not 90 days or 30 days. Team three, 10 days is the correct answer. So the Condominium Act says, before you record an amendment to the master deed, whether that's through the, the voting process or otherwise, you have to make sure that the co-owners have a copy of it or are notified of it at least 10 days in advance before it is recorded. All right, so team three, if you want to go ahead and pick the next category.
Elections for 200.
Elections for 200. The rule that ensures all co-owners are treated the same in the collection process. So it's not bylaws, and it's what we use to prevent selective enforcement. All right, I'm not seeing the correct answer on this one, so I'm not going to award points to anybody, but I'll go ahead and reveal it. So it's a collection policy. So a lot of times the condominium documents are going to provide the meat, or they're going to say, there's these certain late fees or a percentage of late fees, or this is how assessments are allocated. They don't necessarily set up a process when somebody becomes delinquent that, after 30 days, they're going to get a letter from the attorney. After 60 days, they're going to get a lien placed on. If they still don't pay after 90 days, then we're going to go ahead and move forward with foreclosure or some other collection activity, something in that neighborhood. So that's why it's important to have a collection policy, and every association should make sure that they have one. All right, I think it was team three that was up. So if you want to go ahead and pick another category here.
Let's try name that association for 100.
Okay, a type of condominium that is composed of single-family homes. Oh. Nope, so this is a specific type of condominium. All right, not seeing the correct answer yet. All right, I'm gonna go ahead and call time on this one. So it's called a site condominium. So it's kind of interesting. The term site condominium doesn't actually exist in the Michigan Condominium Act whatsoever. It was created as a means to avoid the Land Division Act and put in single family homes. Pretty much every new sub that you're going to drive by is going to be a site condominium. And then it's, that term, it's been accepted by the Michigan courts and actually worked its way into lending parliament as well too. So when you hear the term site condominium, that's a form of condominium that is composed of single family homes. All right, so next category, I think it was team three.
Insurance for 300.
All right. So the insurance policy that covers directors and officers that are sued when acting within the scope of their authority. D&O's pretty close. Yeah, so I'm going to go with team two, director's liability. So what this is called is D&O Insurance, and so that stands for directors and officers insurance. So when you're getting quotes, you want to make sure that beyond just general liability, that you have, especially if you're serving on a board, that you have what they call a directors and officers insurance policy. All right, so Beth, I think you were answering for team two, so you want to go ahead and
Yeah,
I guess.
you will do insurance for 400.
All right. An insurance carrier's obligation to provide an attorney to defend a lawsuit if the lawsuit arguably falls within coverage. Any guesses on this one? Nope.
Mm-mm.
All right. I'm not seeing the correct answer to this one. So the answer to this one is, what is the duty to defend? So what I'm getting at here is that every insurance policy, it comes with two duties for the insurance carrier. So one of them is the duty to defend, which means that if you get sued and any of the claims are arguably within coverage, then they have to appoint an attorney to defend that. The second duty is the duty to indemnify. And so what that means is when you get to the end of the case, you actually have to have at least some form of covered claim in order for them to pay out a judgment. So the important thing is that, you want to try and at least make sure that the carrier, once you get sued, is going to step up and provide a defense as one of the initial things that you want to take a look at when putting in an insurance claim. All right, back to team two here. You want to pick
Insurance for 100.
Insurance for 100. Okay, the insurance policy that will provide for the replacement of the common elements in a condominium in the event of a fire. So it's not association and it's not homeowners. Building coverage is close. All right, I'm going to go ahead and give it to team two. So it's what they call a CGL policy. So it's commercial general liability policy. The Condominium Act and the administrative rules are pretty vague, other than to say that you have to have one of these policies. It doesn't say what the coverage is. But it's important to make sure that you have this because, if you have any kind of property damage, whether it's fire, hail, stuff like that, this is going to be something that you're definitely going to want to have and is going to come in handy and save you a lot of money. So when you're talking to your property manager or insurance agent, this is going to be called a commercial general liability insurance policy. All right, so it goes back to team two again. If you want to go ahead and pick out a category.
Yeah, let's just finish out insurance with 500.
All right. The insurance policy exclusion that may deny an association insurance coverage from defective work by a contractor. Any guesses? All right, not seeing any takers on this one, so I'll go ahead and call time. So it's called the your work exception. So pretty much under that general liability policy that we talked about, pretty much all of them are going to have a your work exception. So that means that if you hire a contractor, somebody to come out and take a look at the common elements, you know, where they put a new roof on and the damage is caused because they had defective work, that you're going to have to go after them and hold them responsible, that it typically will not be covered under your insurance policy. The only exception to that is we did have a case here in Michigan where there was some defective construction, and there was wind-driven rain that ended up getting in the building and causing damage. And even though there was defective construction, the court ultimately ruled that the root cause was the wind-driven rain, which was covered under the policy. So occasionally you're going to see coverage, but typically not. All right, back to team 2 here.
Name that association 200.
All right. A Michigan community association that does not have its own specific statutory scheme. HOA is correct. So as I indicated earlier, Michigan is one of the states, one of the few states that actually does not have a specific statute governing homeowners associations. We have a condominium act, and there are certain other laws, but typically homeowners associations are creatures of contract. All right, so Jordan, I believe that goes to you in team 1 to pick the next category.
Do collections for 500.
All right. The redemption period of a condominium unit that has been foreclosed on and not abandoned. So what's the redemption period? So it's not 60 months. It's not 60 days. 6 months. Team 3, Jeanette has got the correct answer. Good job. So if it's abandoned, it's going to be 1 month under the statute. If it's not abandoned, the redemption period is 6 months. All right, team 3, you want to go ahead and pick the next category?
Do collections for 100.
All right. Illegal for a co-owner to do this if they are dissatisfied with the services being provided by the condo association. That failed to pay, I'm going to go ahead and give it to you. What is withholding assessment? So the Michigan Condominium Act, and there's case law out there that says that if you're dissatisfied, that's not a valid reason to withhold assessments. You need to pay and then take up your dispute separately with the association, which is separate and apart. And a lot of people get this confused with the repair and deduct statute for landlord tenant. All right. So failed. So team 1, I'm going to go ahead and pick the next category.
Let's go with name that association for 300.
All right. A type of homeowners association that does not require mandatory membership. Any guesses? So I'm not seeing the correct answer up there, so I'll go ahead and do this. So most condos and HOAs do require mandatory membership, and that's you have to be if you're a condo, but there are some associations out there, they're called voluntary associations. And so they have a recorded declaration. They may have a set of rules, but that declaration never created or references any kind of a homeowners association. And so if it's not in the recorded documents and it doesn't run with the land, sometimes what will happen is a group of owners get together and they will try and collect assessments. It's very difficult to operate because if it's voluntary, people can come and go as they please, and collecting assessments is often difficult. But We do have some voluntary associations in Michigan. All right, so I believe it goes back to team one there.
Name that association for 400.
A type of community associations where the residents own stock and not real estate. A co-op, yep. Eunice, I don't know if you're on a team. I think we're kind of shy on team two as far as people responding. So, oh, Eunice is team three. All right. So points for team three there. Good job, Eunice, but the answer is co-op. All right, team three, you want to go ahead and pick the next category?
Name that association for 500.
All right. A type of community association that can send a person to jail for 30 days for violating the bylaws. Isn't this interesting? Crappy one. Good answer. But not the correct one. 9 points. Yes, and some people may like this remedy. None, nope. All right, so I'm not seeing, it's not a mandatory one. Give it another 10 seconds. All right, so this is actually still law in Michigan books. There's it was a Daily Devil, but nobody got it. But in any event, it's called What is a Summer Resort? And we have 5 different statutes. We probably have a couple hundred of these in Michigan. They were created under statutes in the late 1800s, early 1900s. So this is still law that's on the books. I've never seen it enforced, and I kind of doubt that it would be enforced, I guess, for this drastic of a remedy. But these are a type of homeowners association that are unique to Michigan and kind of like a quasi-governmental entity that you're typically going to find on the west side of the state or north side of the state. But it looks like we do have a few people that would like to find them in the Metro Detroit area, or at least convert to this as well based on the responses. So we got one last question here.
Amendments for 500.
All right, and so then we'll move on to the second round. All right, the minimum time to obtain a notice and proof of mailing to a mortgagee and amending condo bylaws. Oh, sorry. I gave that a one away if anybody saw it. But anyways, I'm not seeing the, yep, 2 years. All right, so Nancy, you go ahead and get that. But it's interesting because a lot of people will say, how long should I keep certain records? And a lot of people don't realize this. It's tucked away in the Condo Act, but for the records that you send out, the notices to the mortgagees, the proof of mailing and everything, the Condo Act requires you to hold on to those records for 2 years. Interestingly, it doesn't say anything about the notice to the actual co-owners. But for anything that you send to a mortgagee, the requirements under the Act require you as the association to maintain that for 2 years.
Nancy,
right.
what team was Nancy on?
We'll take her on 2.
You got her.
All right, so I switched screens. Can everybody see the round 2 that's up here?
Yep.
Yeah. All right, so I guess before we move on, Ellie, do you want to do a recap of how many points each team has?
Yep, I just put it in the chat, but team 1 is 1,400, team 2, 1,100, and team 3, 2,200.
All right, so it's still anybody's game here in round 2. So who got, I guess we'll go ahead and have team 2, who has the lowest point total, kick us off for this round. We have 5 categories. So we have condo admin rules, Fair Housing Act, Hirzel law, HOA hot topics, and the Michigan Nonprofit Corporation Act. So
We'll go for Fair Housing Act for 400.
all right. Types of services that can be completely banned in an HOA without violating the Fair Housing Act. Any guesses? All right, I'm gonna give another few seconds. Nope, not code violations. All right, so the answer to this one is religious services. So what the Fair Housing Act says is that you're not allowed to discriminate against anybody because of religion. But where you run afoul of the Fair Housing Act is when you start providing preference to one religion versus the other. So there was a case out of Florida. It came back and it said the association did not violate the Fair Housing Act because they banned all sorts of religious services. But if you start targeting Christianity, Judaism, anything like that, and providing, going after somebody because of a certain religious symbol, but you're allowing other people to have, symbols or yard signs, lawn signs, decorations, things of that nature, that's where you can run afoul of the Fair Housing Act and get into trouble. So as long as you treat everybody equally, you can actually ban all religious services. All right, team 2.
Fair Housing Act, the second 400.
So, okay, 200.
It should
so,
probably be 600.
Yep. Let's see if there's, sorry about that. Let me see if I can fix this real quick.
That last one, the points didn't count, did they?
No.
No. So,
All right, so, okay. There we go. Let me fix this up for you. All right, so this was, okay, so that was the one, yeah. All right, so 600?
Yep.
All right. This type of discrimination prevents an HOA from requiring adult supervision for a minor under the age of 18 to use a common area. Any guesses? Well, child discrimination is pretty close, so I'll go ahead and give points for that one to team 2. So it's called, what is familial discrimination? So one thing that is protected by the Fair Housing Act is discriminating against people that have families, especially people that have children. It's a family unit, you're required to have a minor there. So I see a lot of associations, they will make, certain pool rules or say, children can't play on the common elements without adult supervision. There are court cases out there that have held that that is a violation of the Fair Housing Act because you're treating people with children or minors differently than anybody else. So especially with pool rules, I see like a lot of common sense, rules could be invalidated here if you basically say, that a 16-year-old can't go to the pool without an adult. And you kind of have to draft them, based on somebody's ability to swim or something in that nature. So the courts have sort of looked at this and said, well, they hired a 16-year-old lifeguard, so why does there need to be supervision? So this is kind of a tricky subject. So if you're going to start creating rules that really have anything to do with children, it'd be a good time to go ahead and talk to the attorney. All right, team 2.
Fair Housing Act 800.
All right. The minimum amount of time a condo association has to respond to a disability-related request to modify the common elements before it is deemed approved. 30 days is correct. So Nancy, were you on team 2? I think, Ellie, we had Nancy on team 2, right? Yep.
yes, correct.
All right. So great job, Nancy. So this is actually part of the Michigan Condominium Act. So if you get a disability-related request, it's automatically deemed approved if you don't respond within 30 days. The Federal Fair Housing Act, it says that you have to respond within a reasonable time. But certainly, I think if you're taking longer than 30 days, there are cases out there that have said that's not a reasonable time to respond. Therefore, that would be a denial of the request. But under Michigan law, it's automatically approved. All right. So team 2.
Fair housing for 1,000.
All right. An HOA is not permitted to inquire about this type of disability when it receives a request for an assistance or an emotional support animal. Okay. So it's not mental or ADA. All right, I'll give another 10 seconds for any more guesses. So Nancy, I'm going to give it to you for physical. It's not 100% correct, but it's called a readily observable disability. So emotional, you can certainly inquire about. But what the Fair Housing Act says, if somebody, for example, you can tell that they're blind and that they need a seeing eye dog, in those types of situations, you would not be able to, inquire, get a doctor's letter. Stuff that is not readily observable, especially related to emotional support animals and that kind of thing, that is fair game for inquiry and asking for some sort of proof that the person actually suffers from a disability from a medical professional. So we'll go ahead and give this one to Nancy in team 2, but keep that in mind. So if you get a request for a disability, it's certainly a good idea to contact the attorney because this is just a tricky area of law. But certainly if you know the person has a disability and you can, tell it right off the bat, you shouldn't go and put lots of other requirements on them providing proof for that. All right, so team 2 again.
Oh, let's go hot topics for 400.
The minimum amount of time that a owner must notify a condo association prior to renting a unit. It's not 30 days. It's not 12. 10 days. Nancy, you're on a roll here. All right, so 10 days. So this is in the Condominium Act that at least 10 days prior to renting a unit. Obviously, if you have provisions in your condominium documents that preclude rentals or have a different amount of time, you have to comply with those or ban rentals or short-term rentals, certainly. But the minimum amount of time, if there's going to be any renting required by the Condominium Act, is 10 days. All right, so Nancy in team 2, next category.
Hot topics 600.
The federal statute that outright bans community associations from banning U.S. flags. All right. I'm going to go ahead and give it to Nancy with the Flag Act. That's close enough, but we have the Freedom to Display the American Flag Act. So this is becoming an increasingly hot topic I see around the country that we had, some state statutes allow for, state flags, and you get into political flags. We've had cases where we've had to sue people to take down certain types of political flags. We even have Black Matters Lives flags and all these kinds of things. The only thing that you're really, at least under the federal statute, is you have to have an American flag, and the association cannot ban that in the documents. They can put reasonable restrictions on it. Here in Michigan, the Condominium Act, if you have a condominium, says that you can't ban something that is less than 3x5. So if somebody has a 3x5 flag, you have to permit them to go ahead and fly that. But we don't presently have any protections for any other types of flags. So keep that in mind. That any other type of flag besides the American flag is really going to be dependent on what your documents say. All right, so I believe that was Nancy, and team 2 gets to go ahead and pick the next one.
Woohoo! Hot topics 800.
Okay. Hot topics 800. All right, this type of real property is located in a condominium but does not have a tax ID number and is not contained in the local assessment rolls. All right, common area is pretty close, so I'm going to go ahead and give this one to team 1. But it's the common elements. And so I had this situation pop up in a few associations where it's in carports was a good answer as well, because that is a type of common element. But under the Condominium Act, you can assign a separate parcel ID or a tax ID to the common elements. The only thing that you can do is assign a tax ID, actually levy taxes on a condominium unit. So if your assessor is trying to assess taxes as to anybody, or any property that is not a condominium unit, that is illegal, and you should go ahead and challenge that. All right, so team one, you want to go ahead and pick the next category?
We'll go. Ooh. I think I fixed that.
All right.
All right, sorry about that. Condo administration rules for 200.
All right. Says the minimum percentage of their budget that a condo association must designate for reserves on a non-cumulative basis. 10%. Yep, Beth Morgan was the first to answer and get that one right. So good job, Beth. All right.
Condo administration rules 400.
The name and address of every mortgagee in the condo is kept in this condo association record. All right, so this one, I didn't see anybody get the correct answer. So it's actually, what is the book of mortgages? So in the condominium administrative rule, not all associations do this, but it is required that anybody that has a mortgage, that they report that information to the association and the association maintain that.
Condo rules for 600.
If these amenities are owned by a third party, the owner must keep separate books and records for the co-owners to inspect. So we're looking for a certain type of amenity. Pool's close. Playground's close. Recreation, yes, Stacy. I didn't see the team number in front of there, but recreation is correct. So there's actually special rules in the condominium administrative rules a lot of people don't know about, and there are certain requirements if the association owns the recreational facilities and allows third parties to use it. There are specific rules that if a third party owns it and the co-owners are required to support it, that must be followed. We actually got a case back from the Court of Appeals today. They affirmed a motion or a ruling we got from the Grand Traverse Circuit Court that basically said that the developer was illegally charging the owners certain fees because they did not comply with these rules, and the rules require separate documents, inspection, they require an equitable vote, and as a result of non-compliance with the rules, the court invalidated the fees and the Court of Appeals upheld that. So if you're dealing with recreational facilities, just remember tucked away in the administrative rules, there are special rules for that. So let's see, Stacy, were you team one, I believe?
Yes.
All right. So team one, go ahead and pick the next category.
Let's do HOA hot topics for 200.
Michigan corporations are immune from liability for torts related to this virus if they comply with local, state, and federal law. Coronavirus, yep, COVID-19 is correct. So that was in the last year. That was something that the legislature passed and the governor signed. So as long as you're complying with local, state, and federal law, you're going to have immunity from torts. And it's not to say that you won't necessarily get sued, but it provides a pretty good affirmative defense. And so you want to make sure if you're opening recreational facilities, pools, anything of that nature, you're aware of what the local, state, and federal guidance is on that. And they can, as long as you're complying in good faith and you substantially comply is what the statute says, then you should be good to go there. So it's not necessarily strict compliance, but substantial compliance will get you there. So you want to make sure that you have a plan in place for that, especially upcoming in the next couple months here. All right. So team 2.
Okay, so hot topics of 4,000.
All right. The Michigan Court of Appeals has held that this type of restrictions of animals is unreasonable. But it's not breed, but good guess. Weight. So team 1, yes, weight restrictions. There was an association that adopted a weight restriction. I believe it was 25 pounds, and the court came back and said that there's really no proof that a dog that is, 20 pounds versus 30 pounds is going to be any more, dangerous than the other. So they said that that was an unreasonable rule that the association adopted and would not be enforced.
And let's
All right.
do Michigan nonprofit for 400.
400? The time period to respond to a member that requests a document inspection for a proper purpose. So keep going. Maybe it's a good answer, but not quite. So I'm going to go ahead and give it to team 2 for Beth Walker. She said 1 week, but the answer is actually 5 business days, which would be the same as 1 week if you include the weekends. But it's important that if you get these requests in, that it provides a cause of action. If you don't respond, you don't necessarily need to allow the inspection. And I see a ton of these that are not properly done. They're not sent to the right people under the statute. They don't have a proper purpose, or they request a bunch of information that's not reasonably related to that proper purpose. But immediate was also a good response. But if you get one of these in, you want to make sure that you respond to it, or at least get in touch with the attorney right away, because it's not something you can sit on for 14 days, 30 days, anything like that. All right, so I believe that was team 2.
Let's go condo administration for 800.
All right, so nobody wants to go to the Hirzel law topic. I see that's a scary one, but all right. These must be consecutively numbered in every condominium. Units, correct. Team 1, way to go, Jordan. So what the condominium rules require is that every condominium unit be consecutively numbered. Once in a while, I'll see people do weird things by putting letters in there, or do like 40 A, B, and C. The problem with the administrative rules is it doesn't say what happens when you combine units, or if you're adding or removing units. So this isn't something that I've seen enforced a whole lot, but it is in there. All right.
Oh,
Keep
sorry.
on.
You know what? I'm gonna do it. Let's go for Hirzel law for 400.
All right. The year Hirzel law was founded. (2018). Good guess, Eunice. All right, so Eunice was at team 3, I believe, that you're on. So points go to team 3 on that one. So I've been around for a while, but we broke off from CMDA where we were at in 2018. So we'll be celebrating our 3-year anniversary this year. All right, team 3.
Jeanette had to go. She had another meeting.
All right,
So
anybody else?
she was the captain.
All right, anybody else on team 3 want to take over? What about Eunice? You're there. Did you answered the question?
I'll do it.
All
Okay,
right.
let's do Hirzel law 4,000.
All right. Kevin Hirzel is one of less than 175 attorneys in the country to have been admitted to this organization and sits on the National Board of Governors. Any guesses? All right. So the answer to this one is, what is the College of Community Association Lawyers? So anybody that participates in CAI, this is the organization for attorneys, and you can get admitted based on your achievements in academic teachings, writings, presentations, legislative involvement, things of that nature. So this is one of the things I'm probably most proud of in my career, given that they've only admitted less than 175 in the country, and the organization has been around for more than 20 or 30 years. So this is something that's pretty cool that I'm involved in. All right, team 3, back to the board.
Okay, let's do Fair Housing Act 200.
All right. A type of claim an owner asserts if the association fails to intervene in a racial discrimination from another co-owner. Hate's close, but not the correct answer. No, you gotta keep going. All right, I'll give it another 10 seconds. All right, don't see the right answer. So this one, it's actually called a hostile environment claim. And so this is something that you need to be pretty careful about. There was a case recently that came out of Indiana, and in that particular case, the association wasn't involved, the property management company wasn't involved, but they had one co-owner basically to another co-owner's family would just say all sorts of crazy racial epithets, like taunt them. And they, the people that were the victims of this, they reported it to the association, the management company, and they basically said, well, this is a co-owner dispute, we're not going to get involved. What ended up happening is that the association and the management company were sued. They tried to move for summary judgment in federal court, and the court denied that and said that, at least, the co-owner could make out a case against them for failing to intervene in creating what they call the hostile environment and allowing this type of thing to go on. One of the things that was important, to the court's decision is that the co-owner that was saying all these, terrible things, they had been delinquent in assessments, and the association went after them for assessments, and they went after them for that bylaw violation, but they did not go after them for basically other bylaw violations, such as nuisance, that related to this, and essentially making the other owner's life living hell. So the best advice I can give you is, if you see something like this, going on in your association, don't put your head in the sand. And you probably have a moral responsibility to do something about it, but you also, certainly may have a legal one to do so as well. All right, so I think we go back to team 3.
Okay, so what we're going to do is Hirzel law for 600.
All right. The number of Hirzel law attorneys on the Super Lawyers Rising Stars list. Okay, team 1, 5. Good guess. So we have 10 attorneys, and so out of the 5 or 8 full-time ones, we had 5 make it this year. So it's a list that only 2.5% of the attorneys in the state make it on. So I thought that was pretty cool, and I was proud of our group for that. All right. I appreciate the 8 from Beth, though. So team 1, Jordan, I guess, or whoever the team captain is, go ahead and pick the next category.
Yep, let's do Michigan nonprofit for 600.
All right. Maximum time period an association may go without holding an annual meeting without being subject to a court order to hold a meeting. So I'm not seeing the right answer yet. 16 months is getting warmer. 15 months, team 3, very good. So Nonprofit Act, it says that you have to have a meeting every 15, at least it says you have to have an annual meeting If you go more than 3 months, past that time period or a total of 15 months from your last meeting, somebody can sue you. And the court could order a meeting. A lot of our associations kind of struggled with this because of COVID, but we've been helping people put on electronic and Zoom meetings, and that's typically going to be the best way to go if you can't have an in-person meeting. All right, so that was team 3 that I believe got the correct answer there.
All right, well, let's go back to Hirzel Law 800.
All right. Number 1, release on Amazon's practical guides to real estate. Your book, close enough. I'll go ahead and give it to team 1, but what is Hirzel's handbook, how to operate a Michigan condo or HOA? So this is something we put out and published this year, which I was pretty surprised that we had as many purchases as we did. But when it first came out, we were the #1 new release for practical guides to real estate. And I haven't checked lately, but we're typically in the top 100 for their books. So, all right. So team 1.
Hirzel Law for 200.
All right. The number of Hirzel Law offices. Team 1 said 2. That's correct. So we have Farmington and Traverse City. All right. All right. So team 1.
Condo admin rules for 1,000.
All right. The time period a developer has to record as-built plans after completing all buildings and improvements in a condo. So 1 year is correct. So this is one thing I see a lot of developers ignore, and it just gets kind of brushed under the rug. But typically you have projections as to what's going to be built there, recorded in the initial master deed. But the as-built plans, if there's going to be any changes from what was built or any shifting in boundaries or anything like that, they are legally required to be recorded within 1 year of the developer completing everything in the development. All right, so I believe that was team 1, and we'll go ahead and move on to Michigan Nonprofit Corporation Act.
Let's go for 800.
All right. Can be used to vote at a meeting of the members, but not a meeting of the board of directors. Yes, team 2, what is a proxy? So that is correct. You can give your proxy to have somebody vote at a meeting of the members, but a director cannot give their proxy to somebody else to attend a board meeting. So good job, team 2. All right.
For 1,000.
All right. The close of business on the day next preceding the day on which notice of a meeting is given that is used to determine voter eligibility. Drop dead date's pretty close. Yeah, I don't know that anybody got this one, but it's what they call the record date. So essentially what the Michigan Nonprofit Corporation Act says is that you need to have a date that determines whether somebody is eligible to vote. And I see a lot of associations kind of run afoul of this, is that they may allow people to vote, that maybe they paid their dues after the actual record date. But the record date, if the board can either set a record date and it can, let everybody know what that is in the notice, or if the board doesn't set a record date, it's going to be the day before the notice goes out. And so they put it in this garbled language here. But that's essentially what it is. And the record date determines who is eligible to vote in the meeting of the association. All right. So
We
last
argue
one.
for 3 for that one because I said eligibility.
Yeah, I mean, there was that drop dead date, and I think there was one other that looked pretty close, but there was too many that were close, but none of them were right. So I'm not going to give anybody the points for that one. All right, so we got one more before we move on to Final Jeopardy here. And so this one, it's required to send an owner electronic notice of a meeting.
Oh,
So the question is, what do you need to notify, what do you need to do to be able to send somebody, you know, an email notice of a meeting? Permission, yep. So so that looks like it was team 3, but consent. So that's what the Michigan Nonprofit Act requires, that if you're going to send somebody an email, you have to have their consent, or if you're going to electronically notify them, we typically recommend having a form on hand that they fill out, and then they'll put in, you know, their email address, and that's a good way for the association to save on mailings and that kind of thing. So Ellie, you want to go ahead and let everybody know what they have, and then I'll go ahead and switch it over to Final Jeopardy here.
Yes, I put it in the chat, and team 1 is at 7,200 points, team 2, 5,300 points, and team 3, 3,400 points.
All right, so here's what I'd like everybody to do. So for team 1, team 2, and team 3, if you're the team captain, do not send out what you are betting or what you're wagering for the final round here to everybody. What I want you to do is in the chat, go ahead and switch it from everyone to go ahead and switch it to Hirzel Law. And Ellie, that one goes to me, or does it go to you?
Goes to me.
Okay, so go ahead and send it to Hirzel Law, and then Ellie will reveal how much everybody wagered for Final Jeopardy here. So you only get one chance, and we're, you know, instead of all the guesses, so the team captain is going to be responsible for providing their best answer, and everybody can go ahead and put that in. So, all right, so I got team 3's response here. Oh, so I got 2 from team 3. So Jeanette and Eunice. Okay.
I thought I was the team captain. That's why I did it.
Oh, I think the original team captain, I think, came back. So I
Oh,
guess
well,
you.
then good. You can
All right.
ignore mine then.
All right. So we'll go with the original one and see. Let's see. So we need team 1 and team 2 to send me a private message then that has it. Or Ellie, do you have those?
I have one from Jordan, and then Beth, I have one, but I have it from you as well. So I have them. I have team 1 and team 2. And you have team 3, must be.
Yep. All right. So can everybody see Final Jeopardy? Is this up? Oh. Is Final Jeopardy up or not?
Yes.
Yes.
All right. So that's probably not going to work because I accidentally clicked the button. So, all right. So the Final Jeopardy question is: the minimum number of lots in HOA must have to collect electronic signatures to amend a declaration for an amendment that must be signed by the owners and not voted on at a meeting. So if everybody wants to go ahead. So this answer, yep, go ahead and send to me privately. So I have team 3. Ellie, do you have yours?
Yes, but I don't have the answers.
All right, so I have the answer. I have an answer from team 1 and I have an answer from team 3. Do you have team 2?
I don't. So Beth, I think we're waiting on you.
Okay, so I got an answer from Beth.
Great.
All right, so we'll go ahead and reveal the answer. So this is one that's pretty difficult, but it was based on a new law that was enacted in 2017. And the answer is 250. So some homeowners association documents are kind of odd because as opposed to just voting, they actually require you to collect signatures. And what this said is that you can electronically collect those signatures if you have more than 250 lots in your subdivision. So I guess what, Ellie, I'll go through here. Team one, their answer was 5,200, or the original answer, so they did not get that one right. And so what did team one wager?
Jordan said she changed it and sent it to you,
Okay,
but
so
she originally said 3,200 to me.
oh, okay, so team one had 5,200. Oh, that was my
Okay.
wager, not my guess. Okay, so team one wagered 5,200.
Okay,
Do you have a response from team one? Because I don't.
I don't either.
All right, so, all right, so team one, since you didn't respond, but you wagered 5,200, you guys are down 5,200. Sorry. All right, so team two, Ellie, how much did they wager?
2/3 of their amount.
No,
So what
I wagered 0 is what I
Oh.
sent you.
Okay, I got a message from, oh, Beth, okay, 0 they're wagering.
Yeah,
Yep.
so their answer was no clue, so they wagered nothing. So they're at I guess in the lead
50.
right now and where they are.
Yep,
So team three, how much did they wager?
oh gosh.
All
Team-
of it.
All of it.
Wow.
All right,
That's
so
gonna
so team three, they correctly guessed 250. So Ellie, you want to go ahead and tally up what the final scores are? But I'm guessing it was team three that came in as the winners.
No,
Jeanette,
actually-
Don't brag, girl.
Actually, team one had 2,000 points. Did team two get the answer correct?
The only one who got Final Jeopardy correct was team three.
Oh, but team two wagered 0, so they lost nothing.
Yeah, so
Correct.
team one wagered 5,200, team two wagered nothing, and then team three wagered everything.
Okay, so team two has 5,300 still, and team three has 3,200, so the winner is team two.
No, it's double Jeopardy. We had 3,400, right? And
Yeah,
then
if-
it's
if-
doubled.
Oh, okay, yes, so team three wins.
So it's
Sorry, guys.
7,200.
Yeah,
Yes.
so yeah, so they double whatever team three had. So did team one end up with any points?
2,000 points they ended up with.
Okay, so anyways, so congratulations to team three. So anyways, this was a little bit bumpy because it was the first time that we did it, but I appreciate everybody joining.
This was
and I had
fun.
doing it with you, and then we'll probably do it again, and hopefully you guys learn something along the way as well. I kind of got an idea on what types of questions to ask and what everybody's knowledge level was. So I'm probably not going to be in the running to take Alex Trebek's job, with all the guest hosts. So I'm going to have to do this again on my own dime, but I appreciate everybody coming and showing up today. And then Ellie, do you have everybody's contact information in order to get them either a copy of the book or the gift card on the winning team?
I do, and if you think that for some reason I don't have the correct email address to get you our ebook, I will put my email address in the chat, and you guys can feel free to email me if you were the winner.
All right, sounds good. Well, thanks everybody for joining us tonight. And I think we're trying to sort of mix things up with the presentations, and I had fun with this. So I'll probably try and plan something along these lines for next year as well. So everybody have a good night.
Thank you. Bye.
Yeah.
Thank you very much.
You bet.
It was fun.
Cool.
Well, I'll remember you. I'm on the board at one of the condos. So if I need you, I'll be calling you.
Okay, great. Thanks.
Yeah.